Hector, and welcome everybody. I'm very happy to give this presentation about major developments in dispute resolution since the Millennium. And you might ask yourself, why does he talk about this topic? And I can tell you that I have given a general course at the Hague Academy of International Law last year. And in this general course, which lasts 3 weeks, every day you have 2 hours to make presentations, I was free to decide what I wanted to talk about. And usually these classes are about private international law. But I'm much more in procedure, as you might imagine. And so I said to myself, well, it's 2025. We have already 25 years of the 21st millennium. Let's look back a little bit and ask what has happened, what are the major trends, and let's also look a little bit forward to see what do we expect for the future to come. And some of the major points I addressed in The Hague, but updated, don't worry, will be the topic of my presentation of this evening. And does it work? Not yet. Now it works. Doesn't work any longer. Oh no, no, we are a little bit too far. PowerPoint is fantastic when it works. So you will see this in a moment. Oh my God. Okay. Yeah, it's a little unstable. I will take different perspectives on dispute resolution. So I will start by talking about different methods. Then I will go to different levels of dispute settlement and of lawmaking activities, objectives, trends, perspectives, and finally we have to ask where do we go from here? Yeah, what about the future of dispute resolution in the 21st century? So let's start with the different methods of dispute resolution. And we start, of course, with adjudication in state courts. I have a question for you, for everybody, and I know some of you have been to Germany. I have to change that a bit. Okay. And the question is, do you know this staircase? Have you ever seen it before? This is a staircase of the local central court in Berlin. And it was built in the beginning of the 20th century. And it gives you an idea that court buildings are important because they also show the importance of adjudication. And of course, this was the biggest local court in Germany in the 20th century. And there were several hundred judges working. But I find it impressive because it's a local court. It's not a Supreme Court where you would expect such a staircase. And I will show to you tomorrow the staircase of the Supreme Court of Austria. But this one too is an important one. And still today, adjudication is the most important mode of dispute resolution. But we must also be aware that adjudication is primarily domestic. It's not cross-border, it's not international, it's domestic. And cross-border cases are rare exceptions in the practice of justices around the world. But what we can see and what we have experienced during the last 25 years And maybe I should add, but you can see it, this is a little bit also my personal experience being a law professor, a professor of procedural law, looking at developments in procedural law during the last 25 years. We have more and more different methods of dispute resolution. And the first distinction is, of course, between adjudication and ADR and alternative dispute resolution. We have different kinds of alternative dispute resolution, but the most important one is, of course, arbitration. And when it comes to international commercial arbitration, the development started in the 1916 with a famous New York Convention on International Commercial Arbitration, adopted in 1958. And it is now ratified by more than 170 states around the globe. So it's really a global convention. It is a very short piece of legislation. We have only 7 articles and not very long text. But it is a Magna Carta for arbitration because it guarantees the free circulation of arbitral awards worldwide. And in addition, we have other ways of ADR, which are more collaborative. And these other forms, I will very briefly mention them here, because there is also a development. We have classical ones, conciliation, negotiation, also mediation. But then we have today consumer dispute resolution on platform. We have even online dispute resolution in the platform world. And this is the first point I would like to take up here. But before I continue, I have to make a kind of, let's say, caveat. When I was starting this presentation, which by the way will be published in the Recueil des Cours, the Hague collection of lectures at The Hague in the fall of this year, I had the idea I could take up a kind of global approach. But finally, it was not possible. It was not possible because, as I said this morning, everybody comes from a specific jurisdiction, and you cannot look at all developments around the globe at the same time. It's too much. So what I am going to present to you is a more European view, not only a German or Austrian or Luxembourgish view, but a European view on the latest developments. And why do I say this? Because I would like to start with one very much disputed, but very much important piece of legislation, which is the Digital Services Act of the European Union. What is this Digital Services Act about? It is about platforms, internet platforms, and it provides for standards that internet platforms have to follow the moment they are active within the European Union. And I can tell you this is the reason for some considerable disputes at the moment between the European Commission and the US government, because Europe is regulating these activities and the US are not pleased to see that they have to abide. And what is in this Digital Services Act? And I think that's really interesting. There are several mechanisms for dispute resolution, and these are online digitalized dispute resolution mechanisms. So just imagine you have platforms like eBay, TikTok, Meta, Google, etc. Yeah, some of them you know, others are not available here, at least not at the moment. And then users of these platforms, as you do it every day, may post some information, but sometimes it's not information, it's the opposite. And then disputes may arise about violations of privacy rights, etc., or of standards of the usage of the platforms. All platforms have rules general terms, what is permitted as an information, as a content in the platform, and what is forbidden. And the moment some illegal content is uploaded under Article 16 of the Digital Services Act, providers of hosting services shall put mechanisms in place to allow any individual or entity to notify illegal content. And then there is a notice and take down mechanism in the platform, which is based on artificial intelligence, of course. So the content is reviewed, and if there is a doubt about the content, it will be immediately taken down. And now, of course, the question is there any redress mechanism to go against this decision of the platform to take it down? And this is found in two additional articles, Article 20 and Article 21. So Article 20 requires that platforms provide for an internal complaint handling system. So once you have posted something on TikTok, TikTok takes it down because there is a concern about the content. Then the person who has posted it may go to the internal rules of TikTok and complain, that it has been taken down. And then there will be a decision of the provider. And against this decision, usually one would say, go to court. If you are not happy with the decision, then you can start litigation. But the EU lawmaker was a little bit afraid of this mechanism because these complaint mechanisms are not matters of some hundreds of complaints. It's about 10,000s and 100,000s of complaints per year. And so there was a fear that the court systems in the EU member states would not be able to cope with all these complaints. And they established an out-of-court dispute settlement regime, which is found in Article 21 of the Digital Services Act regulation. And there are private providers of dispute settlement which shall provide a decision, a remedy against the decision of the platform. And it is not mandatory. It is an ODR mechanism, but it is for free for the users of the platform, and the platform pay the providers for the services, for the dispute resolution mechanism. And by this mechanism, the EU lawmaker thought they might cope with the problem. So here we are in a fully digitalized world. It's a new way of dispute resolution, which is based on ODR, online dispute resolution. What happened? Here we are on the web page on one of the most famous ADR mechanisms in Germany. It's called Users' Right, and it provides for some redress mechanism for some of the platforms. You can see it. Well, TikTok is included, and they make decisions about the legally or illegal content, about the user rules of the platforms, German private law and German constitutional law, and this is a fully AI-based decision. Who is behind this ODR platform? Takes a little time. I show this picture because you see the elder person there. His name is Stefan Breidenbach. And maybe some of you, well, not you, but some of the people who 27 years ago attended the famous seminar here in Beijing recalled Stefan Breidenbach. He came from Germany to teach here in Beijing together with me German procedural law. Today he is an emeritus professor and he is running this ODR mechanism, which is based or funded by crowdfunding, and it is quite successful. Let's look at some statistics. So at the right-hand side, you have the number of cases which were eligible and decided in 2025. So the whole mechanism started only last year. So it's really a very actual development. And there is another out-of-court settlement body, which is called Appeal Center. And Appeal Center is a very interesting story because behind Appeal Center is Meta. Meta, the Meta Oversight Board, they are very active in Europe with several platforms, and they have their own users rule and they have their own ODR dispute settlement mechanism, which is called the Oversight Board. And now they were confronted with this European idea that there has to be a European settlement mechanism. And what did they do? They set up a legal entity in Ireland. They gave 20 million euros funding to this entity, and the entity is now providing for dispute resolution, which is fine, but only based on general standards of human rights law, whatever that might be, and the user's rule of the platform. Which means finally that these ODR mechanisms decide the disputes only and exclusively about the standards of Meta. You have here an example of privatization of dispute resolution, and it is very well made, but it's also about power. Who has the last word in these disputes? And Meta was clever enough to make its own dispute resolution mechanism. Last word on this example. Look at the number of the cases. Do you really believe that this limited number of cases will be a problem for courts in the European Union? We have 27 member states. Yeah? And you can see that the eligible cases were 12,000 or 8,700. So finally, it is not such a big problem. And one might also ask, why have they, or why did they establish such a complicated and comprehensive system? So this was my first point. You can see how dispute resolution may shift out of state courts more and more to online dispute resolution mechanisms. And the important question here is still, what are the standards applied? Are these mechanisms, these bodies, independent? They are not independent if they are funded by one powerful actor like Meta. Let me turn to the next perspective. Different levels of dispute settlement. You have already heard about this morning, and we can see there is global cooperation in civil and commercial matters. There is regional cooperation in civil and commercial matters. And if there is no cooperation, then we have national unilateralism. And here I'm talking about cross-border cases. So what do we have at the international level? We have global cooperation, and this is something which is interesting from the Chinese perspective because China has become a very important player at the global level when it comes to global cooperation. How does it work? There are three institutions which are involved. You have the Hague Conference on Private International Law. You have the United Nations ancestral bodies, which are primarily in insolvency and in arbitration. And you have UNITROR, an old international organization for the harmonization of private law in Rome. And the Hague Conference is about private international law. Global cooperation, how does it work? Well, we are at the interstate level. Global cooperation requires that there is an international convention, which is the basis of this kind of cooperation. The problem of international conventions is quite obvious. International conventions are concluded between states. Once negotiated, they are ratified. Once ratified, they enter into force. Once they enter into force, they remain in force for 20 years, 40 years, 50 years. I give you one example. The Hague Conference has adopted the Hague Service Regulation. It's about service of documents in cross-border cases between courts of different contracting states, and it is a convention of 1965. Can you imagine how service in 1965 was affected? Well, it went from one court to the president of the court, from the president of the court, maybe to the Ministry of Justice, from the Ministry of Justice to the Ministry of Foreign Affairs, from the Ministry of Foreign Affairs to the embassy in the member state where service should be effected, and then it went down to the court. It took time. I recall in the around the Millennium, service between Spain and Germany took more than 4 years. This is not cooperation. This is chaos. We still have the same instrument for global cooperation, the Service Convention, but the Hague Conference has become very innovative. They have started working with a permanent bureau. They have databases. They have handbooks. They make proposals how to apply the old Service Convention in a new digitalized world, and they even permit now for a digitalized electronic service. What we do at the national level too. So here you can see how by informal mechanisms of cooperation, finally you get a more and more effective regime, but still the legal basis is extremely poor. It's the old convention of 1965. Why is global cooperation so important for China? Well, we have in many parts of the world, not only in Europe, very intense regional cooperation. For instance, in Eurasia. Yeah? But in Asia, the situation is different. Regional cooperation is not really present. And so there is much more global, the global instruments are used for cooperation. And this is one reason why China has become a very important player in the Hague Conference of Private International Law. So many conventions of the Hague Conference, which were foreseen for global cooperation, have been ratified not only by China, but by many states here in Asia to improve international cross-border cooperation. But still, we have to be aware that it would be better to have more regional instruments. And the Belt and Road Initiative is one example where a more regional cooperation is implemented. If you don't have regional cooperation, you have national unilateralism. This means if there is now available international instrument, now we have it, then states will legislate unilaterally cross-border cases. And the approaches, the unilateral approaches, are quite often problematic. Why? Because then states have the idea we must protect our citizens, and that means that the foreign plaintiff might, the foreign party, that's not only the plaintiff, might be disadvantaged. I give you only one famous example. It comes from Germany. You see it, section 23 of the German Code of Civil Procedure. It's the famous umbrella rule. What does the umbrella rule mean? You have a foreigner who came as a tourist to Germany. Let's say a Chinese tourist. And the person, bad luck, does not fully pay the bill of the hotel. Now the owner of the hotel may consider suing the person. Usually he or she would not do it because the claim is too small. But in order to have a head of jurisdiction against a person who comes from abroad, who has no real ties with Germany, just imagine the tourist was only 2 days in Germany, 1 day in Heidelberg and another day in Berlin. So German law nevertheless provides that if there are assets of the foreigner in Germany, a German party or a party can start litigation against the foreigner because there are assets. Now the question is, what are assets? And here there is a case law which says even the umbrella, which was forgotten at the hotel, is an asset which is sufficient to start litigation against the foreigner. This is totally unfair. Yeah. Once you forget something which is of no value, nevertheless permits exercising jurisdiction. So this is national unilateralism. Reciprocity is a way to overcome it, and it is very much applied also in Chinese private international law. Reciprocity means if another state permits the exercise of jurisdiction, then we will do it too. If another state permits the recognition and enforcement of judgments, we will do it too. This is fine because it is an incentive for states to be more generous, and especially in the relationship between Germany and China during the last 10 years, it has really changed and reciprocity has been established. There is one disadvantage. The party who for the first time tries to enforce the judgment coming from abroad cannot rely on reciprocity because there is nothing to prove reciprocity. And this means that the private rights of the party are a little bit sacrificed for the higher interest of cooperation. So here you can see when it comes to cross-border constellation, we have more and more global cooperation. We have intensified regional cooperation, but we still have unilateralism in procedural law to protect the domestic party. 3 levels of lawmaking, and it is, of course, advisable to go more and more to global cooperation. Now we will turn back to more domestic settings. Let's look at different objectives in dispute resolution. So there are some developments which are maybe more present in the US and in Europe than here in China, but I will be very interested to hear your opinion about this, and maybe you see also parallel developments here. So the first one is individual dispute settlement versus pursuit of general interest. And here I have to come back to arbitration and to state adjudication. What is arbitration about? If you look at one of the most famous treaties on international commercial arbitration, which has been authored by an American author, Jerry Bourne, Bond says arbitration is about the settlement of the individual dispute by highly specialized arbitrators familiar with international trade and commerce. What is it about? About the settlement of the individual dispute. State adjudication is different in the sense it's also about the resolution of the individual dispute, but it is less a service, and it is also in the public interest to develop the legal system, to have a uniform legal system, and there might also be a social function to protect a weaker party, something which can also exist in arbitration, but it's much more difficult. So we have here the individual dispute settlement perspective on the one hand side, and a more public interest-oriented perspective on the other hand. And there is a tension. You can overcome this tension the moment you go for an intensified control of arbitral awards. And here we have different standards in different parts of the world. But as we had just the finals yesterday or this morning here in China of the World Championship in soccer, I would like to allude to sports arbitration, which has become a huge market and a huge area of arbitration. And there is an increasing tendency of controlling arbitral awards of sports tribunals for good reason, because athletes cannot escape from sports arbitration. They have to submit to sports arbitration, otherwise they cannot start in the competition. And there is a tendency in state courts, including the European Court of Justice in Luxembourg, the European Court of Human Rights, to go for an increased review of arbitral awards. And this entails that an arbitral tribunal itself will look more at public interests when rendering an award, just to avoid that this award will be set aside. So again, you can see we have two different approaches here, but there are also ways of coming to achieving a common understanding. If we look at the developments during the last 25 years, or even a little earlier, then collective litigation is another development which deserves a lot of attention. My academic teacher, Peter Schlosser, who is a famous German law professor who is now in his 90s, always, or not always, but finally said, to my opinion, collective litigation is the most important development in dispute resolution during the last 30, 40 years. What can we see here? We had, since the 1970s, mass litigation, more and more mass litigation in the US, the class action. This is the model for collective litigation. And it came to Europe, and the European approach was a little different. There was a fear of American class actions, because it is a little entrepreneurial litigation, so lawyers are really triggering class action, collective claims. In Europe, it was much more about consumer organizations, so-called qualified entities, that bring collective actions in the name of many victims or of product liability. Let's take one famous case. It was a Volkswagen diesel case, a scandal when Volkswagen treated customers saying cars were clean diesel cars were clean, but they were not. But they had a special mechanism to cheat. And finally, in the 1910s, there was a famous Volkswagen emission scandal, which started in the US, continued in Europe, and this scandal triggered finally large scale legislation in Europe, where we now have the Representative Actions Directive, which has been implemented in many of the member states. So you can see over the years, we have a development, first a very strict resistance of the business against class actions, against collective litigation, but then we have more and more the idea that we need something also to collect small claims of consumers or maybe even bigger claims and to provide for collective redress for large-scale cases. And I recall after the Volkswagen emission scandal, I was director in Luxembourg, and I got an invitation by the EU Commissioner for Justice and Consumer Protection. And she invited a group of 10 people from the business side, consumer side, courts, to discuss collective litigation. And the commissioner at that moment, the commissioner is like a minister of a government, so at the European level, he said, this is the moment. We have this scandal, and now we have the political support to go for collective redress. And collective redress really changes the litigation. I will come back to it, because collective litigation might also be public interest litigation. And then we have different forms of dispute resolution, which is not only about private rights, but also about public interest. And in the Volkswagen case, it was quite clear. There was a public interest in avoiding these unlawful behavior of the German car manufacturer. By the way, it was not only Volkswagen. There were many others who were cheating too. Okay, here you can see how over the years an expansion of collective litigation took place in many jurisdictions of the world. And this brings me to the next example, where we can see how litigation is being expanded. And the catchword here is private enforcement. It comes from the US, and it is the idea that you can enforce public interest, and you do it usually by public administration. This is why we have public authorities to implement public law. For instance, product safety in the different jurisdictions. But the problem is quite often that public authorities are not strong enough, especially in Western states. They are relatively weak. And this was the reason why in the US, but not only in the US, also in Europe, there was a movement to adopt a perspective on private litigation, which was enlarged to private enforcement, to the enforcement of public interest by private lawsuit. Now the question is, how does it work? How can you make it? And it works in several steps. First, you need a subjective right, a right for damages, for instance, if a norm of public interest has been infringed. Then you need, second step, doesn't come, might come, no, corresponding remedies and procedural empowerment, for instance, class actions. And the moment you have these individual actions and collective redress, then private enforcement may work. This is very abstract and doesn't tell you much. But I give you one example. It's a famous example when it comes. It's the European General Data Protection Regulation. And here you have a very good example of private enforcement. The regulation is about data protection in the European Union. It's not uncontested, I'm well aware, but let's look at the enforcement mechanism under this regulation. So we have first one provision, Article 82, which provides for a new rights for compensation for damages, in case any norm of any provision of this regulation was infringed. So individuals whose rights have been not sufficiently protected by the other side, in the context of data protection, they may go for damages against the possessor. And in addition, we have the possibility to bring individual lawsuits. We have wide heads of jurisdiction. We have rights for information. And we have also collective remedy. So you can see private rights are created, but in order to reinforce the enforcement of public interests here, data protection. And a few weeks ago, I have been involved in one of the biggest data scandals in Germany during the last years. It's a case pending now in the European Court of Justice, and it's about several million of data subjects, and they filed a lawsuit in the civil court in Hamburg for damages against Meta, and these are claims for damages of hundreds of millions of euros. So here you can see how the data protection regulation is being enforced by private actions. Let's reflect a moment. Private litigation is about private interests and private rights. And there is a famous saying of a German proceduralist, Oskar von Bülow, in the beginning of the 20th century, who said, there is no state interest in private litigation. This is not longer the case. Here we are in a different context. And one has to be aware that private enforcement also changes procedural law, because then there is an interest that the plaintiffs get a better access to information, better access to justice, and this also changes the structure of civil procedure codes. Next development. You can see I have some chapters here. Different trends in dispute resolution. So the first one is constitutionalization, and this is something we have at different levels. So in some jurisdictions it is about constitutional law, fundamental rights. In others it's about the content of procedural codes. It's about fair trial. It's about due process. It's about effective judicial protection. And a very famous figure in the constitutionalization process was Jeremy Bentham, who lived in the late 18th and early 19th century. And he was very famous in discussing the importance of public hearings for a court system and for the development of a society in order to have affairs of public interest, of general interest, be discussed in the courts and by the courts. Well, today we have these due process guarantees in several instruments around the globe, but not only in these human rights instruments, but also at the level of procedural codes. And I think among proceduralists, it's also a kind of fundamental understanding that there are some values which must be respected in proceedings, not because we need values, but we need proceedings which come to a good and fair result. And in order to come to a good and fair result, you need due process guarantees like the right to be heard and fair trial. Yeah. Here I can be very short. Another development that we have seen already this morning is effectiveness. Yeah. There is the idea that courts have to be effective in the sense that judgments should be given in a reasonable period of time. And the PIJ, I explained it this morning, is one example how to make it. And it is has become a big topic in the European Union. We also saw it this morning. And effectiveness is, of course, interesting because it is also about the review of the performance of court systems, of judicial work, and it's also a possibility to see and to organize courts in a way that they are able to cope with the case law they have to deal with. I skip here privatization because we have already looked at it. And I continue with different perspectives on dispute resolution. So one perspective has already been addressed this morning, and this is a very interesting concept, which was developed by a famous Italian-American lawyer, Mauro Capelletti, a law professor in Florence and in California. And what he did was interesting in the sense that he published a book series in the late 1970s, which was called Access to Justice. And this became a big keyword for political lawmaking in procedural law. And why has it become so powerful? My explanation here is because we do not really know what access to justice really means. It has different facets, and this makes it very attractive. You can argue with access to justice in different contexts, and it has become a very, very important debate in procedural law during the last 40, even 50 years, around the globe. It has been taken up everywhere. We heard it this morning that it has been taken up in China for good reasons. It started in the Western countries. So it was about legal aid in the very beginning. Yeah. So today we do not really discuss any longer legal aid because many states cannot afford legal aid any longer because litigation has become much too expensive. And still you find it in very interesting context. Let's look here at Article 67 of the Treaty on the Functioning of the European Union. This is about the competences of the Union in judicial cooperation, in civil procedure. And it starts by saying the Union shall facilitate access to justice, in particular through the principle of mutual recognition of judicial and extrajudicial decisions in civil matters. The first part of the sentence has nothing to do with the second part. Yeah? It shows, but it demonstrates to you that this has been a very important catchword. So, for instance, in consumer protection, the idea of access to justice is used that consumers need to be protected. Then there is the idea of access to justice in collective litigation. Yeah, so it expands in the next area of dispute resolution. Then there is a debate about access to justice in ADR, access to non-judicial dispute resolution. So you can see how a concept is expanding. Why? Because Cappelletti never defined it. He kept it open. And finally, we find it, and you heard it this morning, also in the Sustainable Development Goals of the United Nations. Yeah? And here there is again a different focus. It's about vulnerable parties. They shall be protected too in civil litigation. So here we look at the party, plaintiff, often the weaker party, and it is about facilitating access to justice. But this is not the only view on dispute resolution we can find in the development of the last years. So here we still have the idea of the vulnerable party to be protected. And it is a powerful concept. It has been taken up by many resolutions and in many areas of procedural law. But then we have also a different approach, which is based on the importance of different claims. And ladies and gentlemen, this is a very interesting development. Why? Because here we look at the justice system as a whole. And the underlying idea, which was primarily developed by Lord Woolf in the late 1990s in England and Wales, was the idea that there are only limited resources for the justice system. And now we have to allocate these limited resources to different disputes which are brought before the courts. Have you seen the change of perspective here? When it comes to access to justice, we look at the party, the vulnerable party. When it comes to these different tracks of and the different procedures, then we look at the judicial system. Yeah, it's not the individual dispute, it's much more the justice system as a whole which plays a role. And what was the idea of Lord Woolf? He says, well, it is necessary to distinguish small claims, medium-sized claims, and large claims. And it is, of course, clear that a judge needs much more time for a large claim for complex litigation. So we have to establish different tracks of civil procedure. We have to provide for small claims, accelerated, simplified proceedings. They should not last too long. Maybe we don't even need a hearing. We go for written proceedings. And we make it as quickly as possible. Then you have the medium-sized claim where a little more time should be allocated to the dispute, but still limited resources. So maybe the taking of evidence is limited to some means of evidence. And then you have the Mercedes in dispute resolution, if I may say it that way. Large claim and high value claims. And for these claims, there are procedures which can last several days, several weeks, and the court has sufficient time to deal with important commercial claims. In a certain sense, this goes against equal treatment of parties in civil litigation. One has to be aware of it. And I know a lot of justices who tell me when I come with this idea that we should have different procedures for claims of different values, this I cannot endorse. For me, every litigant, every party is equal. And of course, a small claim for someone who has a limited income is not small. It's very important. But here we have an institutional view on dispute resolution, and it has become more and more dominant in the debate. And maybe it is not totally wrong, yeah? Because of course, a big commercial dispute is not only about businesses, it's also about employees who are working in the businesses, yeah? So maybe it's not wrong to allocate more resources and more time to this kind of dispute. And the last development in this regard, and this is a typical, no, not only a typical European movement, but more and more a global movement, is the idea of establishing international commercial courts. So international commercial courts are courts dealing with high value disputes, 100,000 euro amount of value, 500,000, more than 2 million euros. And this kind of specialization of international commercial disputes started in the United Kingdom, but we also have it in the US, in New York, and maybe also in Delaware to some extent. And we have it in Singapore. We have it now in several Arabic states. And after the Brexit, when the United Kingdom left the European Union, also many jurisdictions within the European Union established these international commercial courts. And they have an additional objective, because they shall also compete with international commercial arbitration. And as I told you, international commercial arbitration is primarily at the dispute resolution at the resolution of the individual dispute. And there are some areas of commercial law, especially in English law, where you don't have any judgment of a commercial court, but only arbitral awards. But the problem here is arbitral awards are usually not published. Arbitration is not public. Arbitration is private. It's based on private parties' autonomy. And so you don't have an standing case law, an established corpus of case law, because the cases are not known. The awards are not known. And this is, of course, also problematic. And the idea of the international commercial courts is to bring back some of these disputes into the state court. Still an open issue whether it will work, but it works in some areas quite well. So here we have different procedures for different claims. It might continue with the idea of the multi-door courthouse, that you don't have only different court procedures, but also ADR mechanism to deal with different types of disputes. This is a development which has started, and to my opinion, will continue in the next years to come. And then we have also a constellation which is also relatively new. It's the idea that litigation is not only about rights of the parties, but it's more and more seen as a kind of investment. And here we are in the area of litigation funding. Litigation funding means that an investor enters the situation outside of the court, contacts a party, and promises to finance litigation. And in return, when the case is won, the funder might get 1/3 of the judgment, the value of the judgment. If you have a high
value litigation, it might be 100,000, then 33,000 go to the funder. But this would not be enough for litigation funding. We are talking here rather about values of amount of several millions. As a matter of principle, this is not wrong, because there are often cases between merchants, between businesses, and if you talk to a CEO of a commercial enterprise, for a CEO, legal issues are not interesting. But they want to see how much profit, finally, how high is the risk, what profit is possible, and they will calculate litigation in that way. And this is exactly how litigation funding is working. What you can see here is a legal provision, Article 10 of the EU Directive on Collective Litigation. Collective litigation is very, very often funded by third parties because it is relatively expensive. And therefore, when the European Union adopted the directive on collective redress, the question came up, is litigation funding good or bad? And this is still a totally open issue. The directive is relatively reluctant regarding litigation funding, but there are other member states where litigation funding is seen as something which may help plaintiffs who would not go to court, who cannot afford high-value litigation, to bring an action. And the idea that you win and you get 100% of the value of the dispute is maybe not realistic. And it's better to get 70% than nothing. And so litigation funding, as a matter of principle, I would say it is not bad. It can be helpful for access to justice. But there are, of course, cases of abuse. And let me give you one example, which I do not like at all, but it happened in reality. So litigation as an investment. In the 1980s, Romania, which was a communist state at that time in Europe, delivered many tractors to Zambia, which is one of the poorest countries in the world. And some thousand tractors were built in Romania, sent to Zambia, and they were used in Zambia, but they did not work. So finally, Zambia did not pay the claim. And the claim was about 55 million US dollar. After 1990, there was a new government in Romania, and a vulture fund approached the government and said, we offer to you for this outstanding claim $1.7 million. And they bought the claim and they started arbitration. In arbitration, they won. They got 55 million. And then they went to the UK for the recognition and enforcement of the award. I find this extremely nasty. Zambia is one of the poorest countries of the world. They could almost not afford the arbitration. Now they were in London, which is one of the most expensive jurisdictions of the world. And again, they were losing money, and the vulture fund had, of course, a huge profit out of this business. So here you can see the dark side of litigation funding and the idea that you can invest in litigation. And the big question now is, do we need some regulation regarding litigation funding? And I have to say, my own opinion has changed over years. And in the beginning, I was more optimistic regarding litigation funding, but I think we also need to protect parties whose claims are funded, especially when these are small claims. So when we are in collective litigation, there is a need to have some control. I'm almost done, and then you can ask me whatever you want to ask me. Let's look at the future. What is going to happen in the future? I have 2 points, and I will not discuss them in detail, but we can take them up. One is, of course, digitalization of dispute resolution. And you might imagine that in my Hague lecture, I have a full chapter about this overarching trend. What about courtrooms in the future? Here you can see some web pages in the US. I only made a screenshot and then we anonymized everything. You have court proceedings which are more and more virtual. So you have virtual courtrooms. Parties are not longer present in the courtroom. The same may also happen to the court itself. And now we have, of course, the question, how to organize a virtual courtroom, how to organize it in a way that also parties realize that they are in judicial proceedings, that they respect judicial proceedings. There is also a kind of theater setting when it comes to court proceedings. The hearing is theater, and this helps maybe also to solve a dispute. So this has to be considered, but I'm pretty sure that in 10 years' time we have more and more digital cyber courts, and it is also extremely helpful for a country like China, which is so big. Is it really necessary that witnesses travel to court proceedings far away? So maybe virtual hearings are much better. Recently, I was involved in a case in Austria, which was about an accident which had happened in France with a lorry. And the insurance was sued in Austria by the victim of the accident. The victim was a tourist. Now the question was how to hear a witness. It was a small claim. It was about 6,000 euros. And there is in European law the possibility to have hearings by with the help of digital devices, and video conferencing. And what the commercial court of Vienna is doing in such cases is they contact the driver of the lorry. The driver of the lorry is going around somewhere in Europe because he's busy in his car. And they make an appointment at the moment of the hearing. Very often this is a question to a witness, which is not very sophisticated, very much about how did it happen when the accident occurred. The driver of the lorry may go to a parking where he should do this. And then he switches on his mobile phone and he is connected with the court, and the judge may ask some questions. Very easy, very convenient, not expensive. And the question is this a good way of organizing a hearing? The case went to the Austrian Supreme Court. And the Austrian Supreme Court said, wait a moment. This is a court. This is a state institution. A witness, according to Austrian law, has to come to the court and to testify. You cannot make it via mobile phone, only in exceptional circumstances. You can see here an attitude which is a little old-fashioned. It's the idea that court proceedings has to be in a courtroom. I respectfully disagree. Today we are in different times, and we can also facilitate dispute resolution, court proceedings, by permitting digital devices to be used. The question is how to make it. Yeah? Not only permitting the lorry driver to drive and to answer to the question of the court. This is not an alternative. And I know that also here in Beijing, there are already courts which are highly digitalized, and there is a kind of court etiquette, how to behave in a digital setting. And I think here we have to continue and to move forward. So this is one point to be addressed here. And the other one is a little different. This man is a president of the European Court of Justice, Mr. Kuhn-Lennox. And what I would finally address here is communication and dispute resolution. And in the digital times, there is a new task for the courts to communicate with the society about their activities. And here you can see, if you go around the globe, that there are many, many diverse approaches to communication. And I would like to invite you again to go to CPLJ. There is a video available of one of my lectures about communication of courts, which was given in The Hague, where I went to the different web pages of different courts around the globe. And you can look at them and you can see how courts are communicating today with the larger public. In former times, the old idea of Montesquieu, French philosopher of the 18th century, was the court only speaks through its judgments. This time is over. People do not read judgment. People do not understand judgment. People do not longer go to court to attend hearings. So the judiciary is also it's a task of the judiciary to inform the public about their activities, especially about important judgments. And it is much better when the court itself does it than a journalist or a blogger or someone who is outside of the court system. And the European Court of Justice, in the beginning of this year, set up a totally new web page where they have even court TV, where the justices explain the case law of the court. They explain important cases. You have live streaming of important hearings, and courts are now accessible online. And I think this is a very good development. Of course, one has to reflect how to make it, how far one can go. The judgment is still the most important, let's say, product of dispute resolution. But in addition, it might be very good if the president of the court, especially when it is such a high-profile court like the European Court of Justice, explains also a very important decision in a language which is understandable to the citizen. And here again, we have a change of dispute resolution, of the judicial function in the 21st century, which is no longer simply focused on the court building and the judgment and its publication, but it's much more communicative, much more oriented and in the direction of informing the society, the larger public, about their activities and why they did such a decision. And those who are experts, as you are, we all read judgments and we won't stop reading them. But nevertheless, it is good to have more information about judicial activities also statistics, also information about the length of proceedings, also information how to access courts, etc., online available for everybody, especially when it comes to very long distances between the ordinary people and the court in the different jurisdictions. So here I stop myself. I hope you got some diverse perspectives on dispute resolution. If you start looking at it, I found it quite interesting to see how many developments we finally experienced during the last 25 years. And if I look a little bit towards the future, so we have big trends which will transform dispute resolution fundamentally. One is digitalization, or let's put it that way. One is digitalization. The other one is also collective redress. Another trend, finally, is privatization. We have seen it also when it comes to platform dispute resolution. And we also have more and more regionalism. And here we have also to be very much realistic. We are today in a world where global cooperation between different countries has become more and more questioned, unfortunately. And this implies a rise of regional cooperation. And what is important is to have still global cooperation, a common understanding of values, and also a global academia defending and promoting, maybe more promoting than defending these values. And I understand this event here being one part of this endeavor. Thank you very much for your attention.
Thank you, Professor Hess, for your outstanding lecture. And I have to remind all of you that the lecture belongs to the series of Peking University Law School Distinguished Global Faculty Lecture. So I also remind the last part of your speech especially remind me of your speech last year, legal communication. So I guess many of the participants here would also take part in that lecture. And before that, you mentioned different dispute resolution methods, different territorial coverage of the research, objectives of in-dispute resolutions, the trends, different topics, as well as perspectives. So then I think that we have a lot of information, and especially something that has been skipped in the slides, but we can read it later after the speech. So you will have the slides after this lecture. And then I'm going to invite our commentator. I consult Margaret whether she want to jump in, but I think you can jump in any time you want to talk a little bit. Then first, I'm going to invite Professor Fu to give the comments. Please.
Thank you so much, Professor Hess. And actually, after I listened to your lecture, I realized there's something quite similar trends here in China and there in your report. But I would like to mention the key word that the logic at the bottom of the whole transformation. It's as Professor Hess mentioned, it's the balance between individual rights and the public interest. So am I right if I think some of the tendency happening in the court, it's including, the tendency in the court more and more focus on the public interest, and some of the cases, if it is only focus on the individual's rights, it's more and more kick out or attractive out of the court, including ADR and ODR and something like that. There's not one question from me. It's you mentioned about the consumer dispute resolution. In my mind, this kind of case focus much of the public interest or some public policy, not only focus on the individual right protection. But I wonder why you give a special classification to close the consumer dispute resolution in this side of the ODR and ADR. What's the basic logic, or think about the consideration of the value? Thank you.
Thank you, Yulin, for this very interesting and valuable question. Yes, I distinguish between consumer dispute resolution on the one hand side and ADR at the other hand. Why? You already said public interests are much more in consumer dispute resolution. I will come back to that. That's certainly true. But if you look at classical ADR, which is conciliation mediation, it's a very much individualized process. It's not necessarily online dispute resolution. It is also used, but it is much more, let's say, commercial, individual, maybe also in family disputes. You can see it. There are interests which go far beyond legal norm. And so this is a very specific, important area of dispute resolution, even when it comes to neighborhood disputes, where only deciding disputes according to the rule of to rules of law is maybe not the appropriate way. Let's look at consumer dispute resolution. This is a little different. It is a real legal dispute very often, or a factual one. I got a product which does not work. I want to get rid of it. I want to get back my money. My holiday trip was not well organized. So I want to get compensation because my holiday is very important for my private lifestyle, something like this. These are disputes which are not psychological. The interests are very much to the dispute at hand. There is a different constellation in the sense that there may be a weaker party. So a one-shotter, as one says. So the consumer is not very often confronting disputes with the business. The business is in a much better situation because there are thousands of consumers complaining, and they have, of course, a lot of experience how to deal with these kinds of disputes. And so it comes more and more to mass litigation, to standardized litigation. I did not talk about standardization, but this is also one aspect of digitalization. So it is not so much about individual justice. It's rather to come to a very quick solution in the interest of both sides. And I think this is a separate area of dispute resolution, which finally ends up also in collective litigation, where the individual claim is represented by a qualified entity, consumer association, etc. And in addition, there is, of course, a public interest in consumer dispute resolution, because there is often a misbehavior of the business, which is something to be considered either by public authorities or by the courts. And here I have a problem. I have a problem if you bring all these cases to private dispute resolution body, the public interest may disappear. Because these bodies do not have this interest in enforcing mandatory consumer protection law. They are much more established to settle quickly and very efficiently mass disputes. And this is something to be criticized, frankly spoken. And there is a weakness in the European approach to consumer dispute resolution. They privatize it too much. They even ask the business to finance the dispute resolution bodies, as we have seen in the Digital Services Act. And this is not good for a neutral and independent dispute resolution. So I see the need to have this kind of dispute resolution, but I would say it comes at a price, and we have to be aware.
So thank you so much for your comprehensive outlining of all different kinds of trends and different methods and different levels of dispute resolution. And I also want to thank Professor Fu for raising a very important point. And that is that I think when we think about the different objectives of dispute resolution, and whether it is supposed to just resolve individual disputes, or whether it's supposed to change public kind of interest, protect public interest, to change broader societal conduct. If that goal, depending on where the legal system sits on that goal, then you will have different kinds of methods and different levels and different trends. So, for example, if a legal system is more interested in individual dispute resolution rather than a broader public interest, then it's much more likely to be adversarial, right? And but if you're much more interested in perhaps pursuing public interests, then it'll be much more collective litigation. So, or if you're more interested, your system, individual dispute, then it's much more likely to be privatized. And whereas if it's more interested in public kind of interest, then it's much more likely to have global cooperation, because you want to have a bigger resolution. It is much more, if it's individual dispute resolution, then you're much more likely, your system, to be focused on efficiency, one of the trends. But if you're more interested in the public interest, maybe you're less focused on efficiency and you just want to have the outcome. So I just think that Professor Fu's mentioning of this particular objective, where your system sits, is highly important, and it really helps us to understand all the variety of trends out there now on dispute resolution. So then I have one question, and that really is AI. I hate to say AI. but it is really on the top of my mind and the top of a lot of minds of lawyers in the United States. And it is part of digitization, but it's on a different level, right? You're having artificial intelligence deciding cases. So again, if it's a matter of only individual dispute resolution, then maybe AI can do it. AI can say, you win, you get $50 or 50 yuan. That's AI can do. But if you want more, really idea, broader pursuit of general interest or public interest, a declaration of norms, no discrimination, or maybe the company should implement a broader policy of equality. I'm not quite sure an AI can reach that resolution. So again, I think the trend between whether your system believes more in just resolving individual disputes or more solving societal problem will also reflect on how much your system is willing to adopt AI. But I actually want to turn it over as a question for Professor Hess, because I don't think you addressed that, and I would love to hear your opinion on it.
Thank you very much for raising the question and also for explaining a little bit how the different objectives of dispute resolution are connected to political choices, to cultural background. But there is a third level, which is a technical one. We have to look at procedure, whether they take up these different interests in the appropriate way. Yeah? And for me, coming from a continental background, continental is not a good explanation in procedural law, by the way, but there is the idea that you have public authorities dealing with public interests and civil courts dealing with civil disputes. And the interesting shift is here that the weakness of public authorities entailed that civil courts are more and more acting in the public interest. And now we have to look at the procedural laws. Are they really suited to enforce, to protect public interest? And then you have maybe a different role of the judge in proceeding, protecting consumers. Yeah. And here we can see that much has changed and developed during the last decades too. Now AI, you are absolutely right. I did not address it. I did not address it because in my Hague lecture, it's the last chapter. And I took a little time to reflect about it. And of course, AI will finally decide cases. It is not only supportive. This distinction between a supportive function and a decision-making function of AI is found in the European AI Act. In the AI Act, there are high-risk systems which are permitted but under strict control. And in the AI Act, there is clearly said that AI in judicial decision-making is either not permitted or at least strictly controlled by human oversight. Question is, of course, how to make it. Yeah. But I see AI invading dispute resolution. It's already there. Little disputes in eBay, for instance, they are not decided by humans. It's the same under the Digital Services Act. Notice and take down decisions, they are made by AI. The ODR dispute resolution mechanism established by Stefan Breidenbach, yeah, he told me we make it entirely by AI. Yeah, They can implement the case law of the German Constitutional Court about on the protection of privacy. It's possible to make it that way. So how should we deal with that? I think it is important to look at different types of disputes, but you also might consider a more fundamental issue, which is the question, do parties have a right to a human judge? And this is a perspective which has been taken up very much in Europe. Even the European Court of Justice, in an early decision 3 years ago, already said there is a right to the human judge. But my question here is, in which instance? So maybe you can have a first decision by AI, which might be accepted by parties, but they need a remedy to review the decision. And frankly spoken, this is not so entirely new. Yeah? When you look at payment order procedures, there are, at least in some countries, Germany is a very bad example in this regard, systems where you can get a payment order without any review by a judge, simply by a non-sophisticated computerized system, which looks at the application. There are some technical checks, and then you get a payment order. And if you don't object to it, then it becomes even res judicata. Yeah. So I think we are already a little more progressed than many people, especially from constitutional law in Europe, pretend where we are. And I think this is also acceptable. Then there is, of course, a certain type of cases where we simply need a human judge because the issue is new, or the issue is very much political, or the issue is very much social, or even human, psychological. Yeah. So what is our task here? We as proceduralists, we have to look at different types of disputes and to ask which are the right disputes to be decided more automatically or even by AI, in which instance, what are the safeguards, etc. The European Court of Justice will decide very soon the first case on AI applied in the Polish justice system. And let me just tell you the case, because it gives you a little bit also an idea where the problems are. So this is a case which comes from a Polish court where cases are allocated by an automated system based on AI to the different justices. So Poland is at the moment an EU member state with a lot of tension in the judiciary, political tension. And there was one judge in one court who realized that he got 20 cases and his neighbor 2 doors away only 6. And he was wondering, why is this so different? And as there was this automated AI-based case allocation system, the judge went to the president of his court and said, can you explain to me? In former times, it was about the president, the presidium, to allocate cases within the court. And the president said, no, I don't know. It comes from the Ministry of Justice. Okay. So the judge went to the Ministry of Justice and asked. They said, this is not something to be disclosed. And we have developed this with some businesses. There are some patents, etc. We cannot tell you the algorithm. So the judge said, this cannot be. I get my cases now from a black box, and I don't know how it is functioning. So he was referring the case to the European Court of Justice. The interesting issue here is, it is before the entry into force of the AI Act. Under the AI Act, it would be very clear that this is not permitted as a practice. But Without the AI Act, we have to apply general principles of procedural law. And what we can see here, and this I also find very interesting, is maybe we are witnessing here a new principle, which is transparency. Transparency in civil proceeding, not only knowing what are the legal provisions to be applied, but also what are the IT tools which are applicable and how do they operate. And we can expect a judgment of the Court of Justice in 2 years' time, something like this. It will take some time. I'm pretty sure they go for a grand chamber. So then it's the most important, but also most lengthy procedure of the Court of Justice. But it is so fundamental that it really a case which is quite telling. And I have full sympathy with this Polish judge, saying not because he does not want to work, but he wants to know how his work is organized by these AI devices. I don't know whether I have answered your question, but these are a little bit my reflections on that.
Thank you, Professor Hess. Thank you for your great lecture. Based on your lecture, it seems that we are still living in the same world because we are facing the same dispute resolution problems. We have so much in common. Sometimes we made the same choice. Sometimes we go the different ways. When it comes to AI justice, in our law school, we have the AI Justice National Lab. It's very important. But there are problems. The ideas in the lab cannot apply in the court now. It seems that the AI justice can do so much, but now the court are reluctant, perhaps because the financial problems are reluctant to use the real AI justice as the assistant tools now in China. So I don't know what is the next step in China. Because about 4 or 5 years ago, there's a big perspective for the AI justice in China, but now the problem is very clear. But there are a great gap between the lab and the court. Thank you.
Thank you very much. Well, we are often surprised by the development of AI. I have to say, when I started reflecting about it 1 year ago, we still were in a different world. Yeah? I'm using ChatGPT and other devices to improve the language of my manuscript, and it is impressive how these tools have been improved. AI can help a lot. One example is Italy. The Italian Supreme Court was famous for the length of the proceedings because they get thousands of cassation appeals or second appeals, and often very similar, often very small cases. And the backlog was more and more and bigger. But they had started already in the 1960s, and now I come to the availability of data, all their case law in a digitalized form. First in a very primitive way, then in a more sophisticated way. And I learned from a colleague of us, Remo Caponi, who is now a judge at the Italian Supreme Court, that with the help of AI, justices are able to sort out whether a second appeal raises a new question, an important question, or is a repetitive case. And now they have a disposition rate of 130%, which means that the backlog is decreasing very, very quickly only because they are using these devices. But the justice is now how AI is operating in the system. Yeah? So transparency is there. When it comes to this kind of assisting tools, I'm quite fine seeing AI supporting judicial activity. What we need is a consensus, and here I fully agree with you that we are all in one world, because the problem is the same everywhere, to see what are really the cases where human intervention, oversight is important. And we should not be too generous with AI decisions. Better more human oversight than less.
Thank you for inviting me as an discussant. I am in Beijing from the University of China, and we always speak new phases of justice. And nowadays we should see to focus on new phases of disputes. Yes, and the disputes itself may change. And I will give you an example. When I was young at universities, I buy milk at a supermarket. I will take the bus to the supermarket of colorful, 3 stations away, and I will buy clothing at the clothing market nearby the zoo. I think the students here never heard about this. And when I want to buy fruits, I will go to the morning market. But nowadays, I buy all those platforms in internet. So our everyday life are changed. Disputes are changed. So when we as procedural professionals, when we think about, we need to focus on this dispute, and we need to really to focus on alternative disputes. I will give you an example of this. In China, we have one method of ADR is enforceable notarial document. It's actually not a document under German understanding. It's enforceable contracts. Yes, when the obligations happened, not yet. And this contract will be enforceable. So this, when it has disputes, it will be very complicated. So I don't think this ADR, this kind of ADR, these notarial documents, didn't solve the problem, but increase new questions when they go to the court. So the first thing I think we should really focus on these things and just ask ourselves whether ADR solve the dispute alternatively. I think it's the first question of us. And the second is how the court will face ADR when the new problems came to the court. I will give you 2 examples of it. The first one is so-called jurisdiction agreement between consumers and business. In China, when we use these platforms, there must be an article about dispute resolution. It will underline and with black matter and said, when you have disputes with me, great the industry platforms, you should go to the court of special court. We have this kind of clause between platforms and consumers. And when then we ask whether these clauses are valid. And the court said, yes, it's valid when the platforms informs the consumer. How they were informed is cost nothing, because I only need to mark it. So I think we use this its dispute changed. And the court, the action of the court, in my opinion, it's too, how can I say, superficial. Yes. I think we need to, the court should not be so neutral and said, yes, you are informed. So the clauses are valid. And the second example is you have also mentioned third-party litigation funding. We have a very interesting case happened in Shanghai. And the court lead at least 7 or 8 reasons to say, sorry, this agreement are invalid because of the imagined danger. And at the beginning, the court said, I don't allow this kind of new things. So the court, actually, you said the privatization of disputes, and it's helped court to solve these disputes out of court. But the court said, oh, sorry, I don't agree with this kind of new things. So it's my feeling about your lecture tonight. Thank you.
In for taking up so many aspects, I suggest let me take up some of the points you raised. Digitalization, we cannot escape, and you are totally right. Society has changed a lot, and the idea that courts can remain the same and should not change is not a valuable option. And let me give you one example, Germany again. Civil cases in Germany go down during the last 20-25 years by 30%. And courts are very much concerned about it. And one reason is the insufficient digitalization of the German court system. If you still need to print out things and to send them to court, this is no longer the adequate form of dispute resolution, and parties, if they can, they will choose another provider or even another jurisdiction when they are commercial actors. And this I also have seen in big cartel case litigation, where the German courts simply were not able to cope with the cases in due time. And the next time the parties went to the Netherlands and to Finland. And it was much easier to litigate there, especially when you can litigate in English. And we have also to be aware that the development of AI in dispute resolution, also platforms, etc., this primarily happens outside of the court. It's arbitration, it's online dispute resolution by internet providers, etc. The state and the public institutions are unfortunately lagging behind. But this does not mean that we have to try to keep the path and to keep courts attractive for that. And of course, not everything is fantastic and good. And here I would say when it comes to consumer contracts, online disputes, online contracts, there is a lot of abuses. And sometimes it's also good to have provisions which simply do not permit ADR of some types of disputes. Here, Europe is very different from the US. And in Europe, you cannot escape from some mandatory consumer protection law simply by agreeing the jurisdiction of a foreign court, something like this. It's not permitted. And this is a huge topic now when it comes to disputes with platform providers, because they have now a second generation of different types of dispute resolution clauses. For instance, I have seen some clauses which excluded, it's a little bit the American model, for consumer collective redress. Yeah. And the idea is in Europe, the individual consumer is protected by consumer protection law, but collective redress is a different animal, and therefore we can try as a platform provider to avoid collective consumer dispute resolution or class actions simply by jurisdiction clauses. This will be decided by the courts. It has not yet been decided, but one should not be too generous. And of course, information is important, but is not read finally. And it's always the old story. The moment you conclude a contract, you are happy to come to a conclusion, and you don't care about a future dispute. And this is for consumer and businesses the same. Third-party funding, a last word. There are problems. There are problems, and I would like to refer you to a famous case which has been litigated in England. It's a MasterCard case. The MasterCard case was about payment systems surrounding MasterCard and other credit card providers. And there was a collective action, a class action of about 6 million individual plaintiffs and claims. And it was brought by a very prominent consumer protection lawyer and Mr. Maverick. And after 6-8 years of litigation, it went up and down from the Supreme Court down to the High Court or Commercial Court and the CAT. They came to the conclusion that the expected value of the claim, which had been calculated by more than £6 billion, was about £200 million. And now the representative plaintiff, Mr. Maverick, settled the case. Settled the case for 180 million pounds. Everything was fine. The defendants were fine. The plaintiff were fine. But the litigation funder was furious because they had calculated it differently. And they started going against the settlement, which was okay. But they also said, the lead plaintiff, that they would start arbitration proceedings, which were foreseen in the litigation funding agreement. And now the lead plaintiff approached the defendant, MasterCard, and told them, I'm facing a problem here, arbitration. Can we agree that you give me 20 million euros for my defense costs in the arbitration proceeding? All of a sudden, the role of the parties changed completely. Yeah? And then it was still the question whether the settlement would be approved by the court, which was finally approved, because the litigation funder had an own interest, was standing outside, and the settlement was considered by the court as fair. But still we are waiting the outcome of the arbitration. This gives a little bit an idea of conflict you might have in litigation funding. On the other hand, And here I also would like to be clear. It's a very nice defense for the defendant side, the business usually when it comes to collective litigation, to say, well, there is too much influence of the funder on the plaintiff side and the individual plaintiffs are not sufficiently protected. Wait a minute. This is not the task of the defendant to protect the plaintiffs against their own funder. Yeah, we have to find a different way. But this argument has been endorsed by the German Federal Supreme Civil Court a few weeks ago. When I read it, I was really surprised. Yeah. So there are many open issues, but litigation funding is certainly something. Either you look at it from an academic perspective, or you will be confronted with it in practice. Thanks again.
I say the time is, we are running so late. Thank you, Professor Hess, for this great speech. And your title says major developments. But having heard the content, I would say I think it's far more than major. It's truly comprehensive, thorough overview about the dispute. I think it really reflects your deep and holistic grasp of the entire dispute resolution. I think any single of the issue you touched could be a dissertation topic to all of our students sitting in this room. And I also want to say that all those issues you mentioned are all alive and real in China today, right now. Our colleagues, other comments have all mentioned this before. Online dispute resolution, collective disputes, the third part, litigation funding, all of them. And I think Chinese scholars have actually done very well work on each of them. So to me, I think it confirms a point Professor Fu made this morning. After decades of development, comparative law research in China is no longer one-way street for importing ideas from the worldwide, but Chinese civil procedure scholarship is now in a position to make its own contribution to the global civil procedure law fields. So that's my comment. I don't want to waste time to ask your question. I think I suggest we leave the remaining time to our students to give them some chance to raise questions. Thank you.
To reserve the time for the participants. So I would like to collect a question from all of you if you have. The first one, and does anybody else have some questions? This one, only one, right? Yeah, please then. Have a microphone.
My question is actually particularly want to address one of the interesting slides you put on. I think it's Judge Byron Harry Wolff talking about different procedures for claims of different values, that slide. And so at first glimpse, I feel like it is a very utilitarian approach. So I would like to ask, when Wolff's talk about different values, is he primarily talking about monetary value, or as I believe it's talking about a hybrid of public interest and individual interest? And if so, do you think in the near future who or what party or which entity is going to make a shot to call the shot of what is a value that fits a certain procedure or a lower value that fits for a different procedure? I think that's my question, and it is because I think given the rise of AI and all these late development of automacy, I feel like it gives rise to all these sort of usual critiques to utilitarianism. Thank you. So, yeah.
Thank you for your question. I share your concern about the different values and the underlying interests and how to find the right balance between the different values and the public and private interests behind. There are certainly some types of disputes we have to sort out immediately, regardless of the value of the claim. And these are family matters. They are so important. They need to be decided by special courts, special jurisdictions, also in special procedures. When it comes to civil and commercial claims, this is certainly a little bit also the choice of different systems. Just look at the differences of income in different countries. And this might already be a reason to make different approaches. It is certainly a policy decision, but there should be a control, and here I'm very much European, under constitutional law, if there are some claims sorted out too easily. What I see in the future is something we can already see in England, where you have this idea of multi-court, of the multi-door courthouse, which comes originally from the US or from Scandinavia. And there is the idea to combine even ADR and court proceedings in one system where you bring your action or your claim online, and it will be allocated to the best suited system. It might be the value of the claim, but it might also be required that you give some information about ADR attempts, mediation attempts, etc., to come to a quick settlement. And here I have a problem. I have a problem because I think finally there must be the right, you have to respect the right of each litigant, even in small value cases, to go to court. And courts should not be the last resort. And this is something which is imminent in these new type of dispute resolution platforms, multi-door systems. And I think the right to a natural judge in the proper sense of the term should be something we should try to keep as long as possible. Maybe this answers a little bit your question.
Because you want to ask a question? But I now see 5, so I cannot let all of you have the questions. I would like to, on behalf of Professor Chen Gang, to ask a question to you to conclude the session, because I cannot reserve all of you here for additional 15 minutes or something like. Professor Chen Gang is very glad to see that you respond to his comment in the morning session about the number 16 goals of the UN Sustainable Goals. And then his question would be, what's your understanding of the access to justice? What the meaning of justice here? And just more than legal aid, you talk about that. What is your understanding of the access to justice? A very short question.
Answer would be, it's not access to justice, it's access to effective judicial protection, which is, of course, a change of the terminology. But nevertheless, if you go for effective judicial protection, you have already the idea that you need a judge there. It's about protecting. And effective means there is also a matter of degree. So this idea that we have to distinguish between different types of disputes and claims is needed. But we should not forget the vulnerable parts of the society, and we have to provide for them also possibilities to bring legal actions. Let me finish maybe with one, let's say, impression from Austria. Austrian civil procedure is very specific. It's very different from the German one because it has always been understood that courts are state institutions, public institutions, and they have to support litigants, especially per se litigants. And in the local courts, there is one day per month where the justices are simply there that to hear plaintiffs, to hear claimants, to hear parties, and to give advice in a very hands-on way and not in a formalistic way, and to be there for the little dispute. And this is a system which is quite successful, but of course it is expensive. But nevertheless, maybe justice has its price for good reason.
Thank you, Professor Hess, one more time, and thank you all the commentators and participants. This is a conclusion of the first global faculty lecture, but not the conclusion of the summer school. So we still have tomorrow. So I don't want to swallow Professor Hess today because he really have a long day, guys starting from the football match. I mean, it's really a long day. So then when we meet tomorrow at 9 o'clock, then we'll continue our conversation, getting started with the lecture prepared well by Professor Margaret Wu, and then in the afternoon section, we will have Professor Hess one more time. So thank you, everybody, and then we're going to see you tomorrow. Thank you.
It's a long day.
Well, I had some break.